So how much time, Mr. Perillo, would you like to be able to do that?
I'm going to, well, I'm going to ask for a couple of weeks time to start on the trial issue date. So I'm trying to devote as much time to that, but I will put the supplement together and provide it to the court in a couple of weeks.
Okay. All right, so looking at my calendar, you have it to me just after the holiday, so like on Tuesday, May 26th.
Yes.
That gives you about 2 weeks and 2 days.
Thank you.
All right, and in fairness to the state, anything that is filed as a supplement by Mr. Perillo, if the state wishes to also submit, a response to that, that's fine as well.
Thank you, Judge.
All right, so moving on to the second motion for today. Mr. Perillo, you may proceed when you're ready.
Second motion for today, Judge, is motion to transfer jurisdiction to Juvenile Division of Circuit Court on grounds of Sixth Amendment violations of required jury determination of factors which increase maximum punishment and/or minimum mandatory punishment. Judge, I filed this motion on February 16th of this year. Again, I rely on the 5th, 6th, 8th, and 14th Amendments of the U.S. Constitution, Article 1, Sections 2, 9, 16, 17, 21, and 22 of the Florida Constitution. So as kind of outlined in the prior motion in a way, we have a scenario where Ms. Egler was under the age of 18 at the time of her arrest. She's obviously arrested. The decision is made to direct file a grand jury return an indictment for 2 counts of first-degree premeditated murder, and we're here today. Now, I'll say acknowledge that there's a clear law in the state of Florida that childhood and adulthood is drawn at the age of 18. Florida does have rules in place for juveniles to be charged as adults to be direct filed. Now, the issue is going to come up because, and I kind of have to, in a way, sort of rely on what I know the state's going to rely on, because I have to distinguish it from where we stand today with the law, and that's part of my motion as well. There's 2 cases that at least were provided, at least going through the cases that Ms. Fowler sent out that I'm going to talk about regarding this motion. One is State versus CW, 62 Southern 3rd, 1261, 2011 case from the 3rd DCA. And the first issue with that is, well, actually both cases. The other case, Judge, is Kirkland versus State, 67 Southern 3rd, 1147, first DCA case from 2011. Both of those cases predate the decision in Elaine, the decision in Miller, the decision in Erlanger, and the statutes that the Florida legislature came up with after the Miller U.S. opinion. So my position is these 2 cases really don't apply. Now, it all begins, Judge, with Apprendi. And I know Apprendi is a 2000 case. So obviously there is Apprendi predated Kirkland case and the CW case. And there is mention of Apprendi in the Kirkland case in talking about how other states, there's no decisions in the state of Florida regarding juveniles and Apprendi. They look to other jurisdictions. But again, it doesn't apply because it is years before Miller comes out from the U.S. Supreme Court. And Miller is a major component to this. So we know in Apprendi that before someone can get something more than an enhanced penalty, essentially, the issue has to go to a jury, and the jury's got to find it beyond a reasonable doubt. Apprendi is clear. I have cited Apprendi in the motion. Apprendi versus New Jersey is 530 U.S. 466 U.S. Supreme Court decision from 2000, where the U.S. Supreme Court said it was unconstitutional to remove from the jury the assessment of facts that increases the prescribed range of penalties to which the criminal defendant is exposed. Such facts must be established by proof beyond a reasonable doubt. Apprendi bases it on judicial fact finding. The maximum punishment in that case faced by the defendant increased from 10 years to 20 years. The judge in Apprendi, the trial court, imposed a 12-year sentence. And even though it was only 2 years more than the maximum, it still violated Apprendi's rights under the Constitution. In our case, Judge, we're talking about a much bigger punishment or significant punishment than 2 years. So if the case is in juvenile court, Ms. Egler is not looking at life without the possibility of parole. It doesn't come close to that. She's looking at essentially being on some kind of supervision, programs, custody, supervision, not probably for another 4 more years of her life, a little bit more than that. So clearly not the rest of her life as it states now. So Elaine, which is a 2013 decision from the U.S. Supreme Court, again, after Kirkland and CW, extends Apprendi's holding to facts that increase a mandatory minimum sentence. So in Apprendi, the minimum sentence was 5 years for carrying a firearm in relation to a crime of violence, but 7 if the firearm was brandished, and in 10 if it was actually discharged. The trial court in Elaine imposed a 7-year sentence despite the jury finding Elaine had used or carried a firearm. Justice Thomas, who wrote the majority in Elaine, said that the Sixth Amendment was violated by this 2-year increase in the minimum sentence. And again, in our case, we're not talking about a 2-year sentence or difference. We're talking about a significantly bigger difference. So when you look at Elaine and Apprendi, just at those 2 cases, the maximum sentence for a juvenile is juvenile sanctions. To increase that potential, my position is, especially according to Elaine, needs a jury finding. So a jury would need to make the finding first. Is this child one of those that should be charged, should be viewed as and convicted, there's a conviction, as a child? Or should they be looked at and convicted as an adult because of these other factors, aggravating factors? Not aggravating factors in terms like the death penalty, obviously, but some other aggravating factors. What makes it worse than a child, in a case involving just a child and keeping them as a child? Now, I cite you Kent as well, Kent versus U.S., 383 U.S. 541. It's a 1966 U.S. Supreme Court decision. But in that decision, the Supreme Court expressed constitutional concerns with procedures that affect the minimum and maximum punishments for juvenile offenders because of the different systems. And again, this is decades before Graham and Miller and Montgomery and all the other cases that have arisen over the last decade or so. In Kent, he said, as a result of the youth's right to the exclusive jurisdiction of the juvenile court, and considering particularly that decision as to waiver of jurisdiction and transfer to the district court, potentially as important to the petitioner as the difference between 5 years confinement and a death sentence. We conclude that as a condition to a valid waiver order, petitioner is entitled to a hearing and a statement of reasons for the juvenile court's decision. So 50 years ago, the Supreme Court is telling us juveniles need to be treated differently, and they need to be treated differently even upon how we charge a juvenile, because of the major differences from a juvenile sanction to an adult sanction. And 50 years later, Judge, it's still valid concerns. Justice Scalia in Apprendi, Justice Scalia wrote a concurrent opinion. In that opinion, he disapproved of judicial fact-finding, saying that the facts that determine the length of a sentence to which a defendant is exposed would be determined to exist on a more likely than not basis by a single employee of the state. And Judge, that's essentially what has happened here in our case. An employee of the state has determined, well, we're going to choose to charge her as an adult. Not a judge, certainly not members of a jury. And when we look at our own statutes, we know that the kin factors have been codified in our statute, which is 985.556C, that talks about transferring a juvenile out of their exclusive original jurisdiction. Those factors, Judge, become elements. Just like not every murder can be a first-degree murder. There's certain elements that make it a first-degree murder. Not every first-degree murder can be a death penalty eligible first-degree murder. I don't mean to digress, but the more we add aggravators, we're essentially making it that every first-degree murder could be a death penalty murder, but that's argument another day, different case. But in those cases, the state has to file with the court specific aggravating factors that they believe they could prove to a jury, unanimously to a jury beyond a reasonable doubt, to make it, to enhance it from plain old first-degree murder where the mandatory maximum is life without possibility of parole to a potential death sentence. And the same holds true here, Judge, because again, we are taking the potential maximum in juvenile and doing away with it and making it a maximum penalty of potentially life without the possibility of parole. Miller did away with mandatory life sentences for juveniles, but it doesn't do away with them completely. It talks about that they are entitled and need a special sentencing hearing. So in our case, what needs to happen, should happen, if we're going to follow the Constitution, follow Apprendi, and follow Miller, is the jury determining, does this person get juvenile sanctions, or are they going to be held to criminal sanctions? And then further, and have a motion that not noticed for today, for another day, that gets into the jury then should be determining what part of the, what I call it the Miller statute, or statute that's come into place since Miller versus Alabama, should they get life without the possibility of parole, or should they get the minimum of 40 years with a 25-year review? And it gets me to, obviously, talking about Miller, Judge, within Miller, it talked about, again, having a hearing. But that's for determination of sentence. We then, in 2024, get Erlanger. Erlanger versus U.S., 602 U.S. 821. And the U.S. Supreme Court in Erlanger says that a judge's power to punish derives wholly from and remains always controlled by the jury and its verdict. So we cannot get to a lawful constitutional verdict in this case without the jury making a whole host of findings, beginning from should Ms. Egler be facing juvenile sanctions or not? Yes or no? And then the next step, which again I'm getting ahead of myself with next week's motion, should she get life, or is she not one of those incorrigible juveniles, therefore get the minimum of 40 with a 25-year review? And sure, I covered my bases, Judge, before I sit down. And as stated in my motion, Judge, the absence of a jury determination regarding the waiver from the exclusive original jurisdiction is limited to dispositional alternatives for delinquency prosecutions to a maximum age of 21. So that's the drastic change we've done, is that she's facing sanctions up to the 21 years of age if it stayed in the original jurisdiction. We're completely doing away from that. It's not a 2-year addition. It's not a 5-year addition. We're literally going from you will see the light of day, when you turn 21, to potentially you will never be free again, that you will die in prison. That is the dramatic shift we're making without a jury determination. And again, Elaine is crystal clear. Erlinger is crystal clear. That authority for a judge can only come from the jury giving the judge that permission, essentially. We give you the permission now to sentence this person as such, or as to this charge, but also potential sentence. So again, relying on the cases that I just or cited in my motion and discussed today, Judge, and the 6th and 8th Amendments and 14th Amendment to the U.S. Constitution, we're asking that the court, and again, I'm not conceding my prior argument that the case should be dismissed, the indictment should be dismissed, but we're asking that the court transfer this case back to the original jurisdiction, which would have been the juvenile court, and proceed in that manner, or and again, I'm going to be back next week with a motion asking for, in the alternative, a jury, essentially a penalty phase jury, should we go to trial, and if there's a conviction of at least one count of first degree. Well, actually, it doesn't matter first or second degree murder, because life is a potential penalty for both. So, but I don't want to get into those arguments today. Thank you, Judge.
Again, Mr. Perillo referenced the case law I previously provided, and they're older, but they're still good law. And in looking at Kirkland v. State, cited at 67 Southern 3rd, 1147, first DCA case from 2011, it's very clear that the defendant's not entitled to have a jury determine facts supporting transfer to adult court. It's well established. It's well established we can direct file any juvenile that's 16 or 17 for any felony offense, let alone a murder offense. And there is really no such thing as life without parole for juveniles at this point. If you look at the sentencing statute of 921.1402, she's going to get a 25-year review. And at that point is when the court makes that determination of permanently incorrigible. So at this point, the state has exercised its discretion. This was actually taken to the grand jury. Juvenile appropriately finds herself in adult court. Any special findings by a jury as to whether she killed, intended to kill, those are made through the verdict form. At this point, the case is where it's supposed to be.
All right. With this particular motion, the Kirkland case and the CW case, I mean, they pretty directly state that the decision to proceed in the adult court rather than the juvenile court was a pretrial choice made by the state attorney pursuant to section 985.557 Florida statutes. Again, that was issued back in 2011. I understand the defense's argument about it predating certain other cases. But at the end of the day, the Apprendi and those types of cases were dealing with post-trial enhancements with sentencing and the inability to do that. This is, I do understand, jumping from juvenile court to adult court changes the penalty substantially, but at that juncture, we're at a different stage in the case. I haven't seen anything in the case law presented to me to show that Kirkland and CW are no longer good law. There's always going to be constitutional arguments based on the line of cases that have come down the pike since Apprendi. But again, I think the distinction there is that, you know, the post-trial enhancements versus pre-trial decisions that are given to the state prosecutor. So unless I have missed something, Mr. Perola, with respect to a case that would tell me that Kirkland and CW on all fours is no longer good law, then I think I would at this time need to deny the motion.
No, Judge, I don't have anything other than to say that obviously Kirkland and CW have not been looked at again since Elaine Miller and especially Erlinger, which is 2 years ago. So preserving this issue, obviously, and I do believe the U.S. Supreme Court, which is a much higher authority than respectfully our DCAs, are telling us, spoon-feeding us, that certain things cannot happen without a jury. Justice Scalia was telling that to us the whole time he was on the U.S. Supreme Court. Especially in criminal cases, the jury has a lot of say. They're the ones that provide permission to the court to do certain things in sentencing. And if they don't give the permission, the courts can't act. And when they act unconstitutionally. I think that is clear, black and white, from a whole host of opinions that the U.S. Supreme Court is spoon-feeding us since Ring and even pre-Ring. And some legislatures act swiftly and some don't. And I think we're down the path because I remember years ago arguing that a juvenile should not go away forever automatically. Lo and behold, Graham came out, and then lo and behold, Miller came out. So I think the message is out there. The message is clear from our justices. And again, a case from 2011 needs to be re-looked at in light of the very clear U.S. Supreme Court opinions that we have received in the 15 years since Kirkland and CW. So, and Judge, I respect the court's ruling. I understand it. I know exactly where the court's going with it. But I do want to mention one thing when Ms. Fowler said that life is not an option. It still is. Miller did not do away with life without the possibility of parole. And our statute, 921.1401, doesn't do away with it either. The court can sentence her to life, like real life. Except, but you must find that she's one of those incorrigible juveniles. And if you don't, then you have the minimum mandatory of 40 to fall back on. So it's not an automatic 40, it's a minimum of 40. But the court could still sentence her to life.
And just to confirm, there are presently no appeals up at the higher level that are dealing with the issue. I know it probably is not an issue that comes up all the time.
Not that I'm aware of.
Okay. All right. Well, as everyone is aware, my job at the trial court level is to follow our appellate and our state appellate and Supreme Court dictates through the case law and through statutes. And as of right now, again, understanding certain constitutional arguments and the logic in them, the authority I have to follow is such that at this time, I'm going to be denying the motion. I will follow up this particular ruling with a written order. And with respect to the first motion, obviously that's, under reservation pending the filing of the supplemental materials. Once I receive that, then we'll figure out the appropriate way to proceed. Okay. Anything further for the record for today?
Are we approach?
Yes. Okay, so I believe that will conclude matters for today's purposes, and digital can go off the record.
Thank you, Judge.
All right, thank you.